of Her Majesty's decision straightforward and another.
Yes, please, Your Lordships. I made submissions yesterday afternoon on the construction of paragraph 14 in the commencement order, and also I started submissions in relation to the concept of custodial period in section 2646 in relation to the proposition that if the appellant was right, that couldn't be operated in relation to the sentence of less than 12 months. And I made the point that given the amendments to exclude intermittent custody orders from section 264 before this commencement order came in, there's nothing to suggest that that was intended to be anything other than a comprehensive definition. Lords, in my submission, that approach would be consistent with the general structure and approach of Chapter 6 of the 2003 Act, which we say, when one looks at it, is based on, throughout, on precisely defined concepts and precise calculations, and it would be surprising if custodial period had been intended to be a merely partial definition.
Well, the trouble with all of this is that the draftsman had in mind that the whole of the Act was going to be working as one.
Yes.
And if you then don't bring perhaps the most important part of the Act into effect at all, it's quite difficult to make sense of what's left.
Well, more undoubtedly, having in effect, two statutory regimes operating in parallel does make for difficulties. It spoils the simplicity of either set of provisions. But it remains, we say, a decisive guide to what paragraph 14 in the commencement order must mean if it cannot be operated on the appellant's construction. And Lords, we submit there's beyond what one takes of 2646 and its comprehensiveness or otherwise, there is actually an even more fundamental point than that. My learned friend Mr. Weatherby, when, as it were, challenged to address the question of how you identify a custodial period for the sentence of less than 12 months on his approach, goes back to the 1991 Act. And he has to do that because, as my Lords have seen, under the 2003 Act, the custodial period for a sentence of less than 12 months is a creation of the sentencing judge. It's specified when sentence is passed under section 181, but that's not in force. Now, Mrs. Justice Dobbs was unattracted in the Highton case to going back to section 33 of the 91 Act to get half the sentence as the custodial period, because she said that that involved mixing and matching different statutes in a way for which there seemed to be no warrant in either the primary legislation or the commencement order. But in my submission, it goes even further than that, because what is the position of section 33 if my learned friend is right in his construction of paragraph 14 of the commencement order? Let's remind your Lordships that at page 108 of the appendix, you see paragraph 44.4k of Schedule 1 to the commencement order, which brings into force the repeals of the 1991 Act insofar as they extend to, amongst other things, sections 32 to 51, including, therefore, section 33. So it's gone. It's been repealed. Now, the only provision that keeps section 33 in existence for any purpose is paragraph 14, the provision with which we're centrally concerned. But the whole point of my learned friend's argument is to say that in a case of this nature, paragraph 14 doesn't apply. But if he's right about that, and paragraph 14 doesn't apply, then it simply follows that section 33 has been repealed, and there is nothing to preserve its effect in any way. And it must, therefore, in my submission, be impossible then to point to section 33 in order to derive a custodial period for the purposes of doing the section 264 subsection 2 calculation. So in effect, the appellant's case is hoist by its own petard. Either paragraph 14 applies in a case of this nature, in which we are right, or it doesn't apply, in which case section 33 has gone. And if section 33 has gone, you cannot work section 264. So it follows that the appellant's construction is one which simply cannot function. Once section 33 has gone, there is nothing whatever left to say that the individual gets out, if we take a 10-month sentence, any sooner than after 10 months. So if you wanted to take, as it were, a common sense natural meaning of the custodial period, if you rejected my submission that it's a term of art, it would be 10 months, not 5 months. There would be nothing to make it 5. And, Lord, I don't want to labour that point, but we would submit that actually it is an unanswerable objection in itself to the construction that my learned friend Mr. Weatherby is advancing here. And so, Lords, we say, both because of what we submit about the natural meaning of paragraph 14 and the issue of custodial period, there is only one possible interpretation of the provisions, and what the appellant advances, therefore, is not an exercise in interpretation, but rather in papering over legislative cracks in order to try and render a different reading of paragraph 14 workable. And the real argument for the appellant, therefore, is that the Secretary of State's construction of the provisions leads to such absurd consequences that it simply has to be read in some other way. But we say that would go well beyond what is permissible. It would not involve simply the resolution of some ambiguity or some modest reading in, but a complete rewriting. Because really, when it comes to it, the appellant's complaint in this case is that in circumstances where, on any view, two statutory regimes do exist at the same time, and therefore transitional provisions of some kind have to be made, the draftsman of the commencement order has adopted a simple solution of saying that one regime applies to the longer sentences and another to the shorter sentences. And the appellant says that that simple approach is not good enough to stop anomalies arising, and the draftsman ought to have adopted a more sophisticated approach in which an aggregation provision of some kind was laid down for mixed cases, identifying what period ought to be taken for each sentence, adding them together, and then stipulating which set of home detention, curfew and licence duration provision should apply to the end result. But that is simply a provision which does not exist in the commencement order. And supplying it, we submit, would go beyond any legitimate exercise in interpretation. Lords, I only want to say two other things about that. One of them is to remind your lordships that to adopt the appellant's interpretation does not all work one way, because it does lead to a longer licence period, in at least some cases, than a natural and normal reading of the legislation would.
That was precisely one of the objects of the exercise of the 2003 Act.
My Lord, as a
matter of policy.
As a matter of policy, for the sentences to which the 2003 Act applies, that is with respect absolutely right, but that still raises the question as to whether one can appropriately apply that policy in relation to a sentence to which the 2003 Act has not been brought into force. But my point is a slightly different one here, which is that if your lordship adopted the appellant's construction, then the court would be adopting, at best, a strained reading, but in a way which would penalise some people. Now, of course, the instant case that is before the court is one in which Ms. Noone is saying, in effect, I would like to be out earlier on home detention curfew, and she was an individual where there was no reason to suppose she wouldn't get out on home detention curfew if eligible. So she says, adopt the strained construction because that benefits me and it gets rid of some of the anomalies. But suppose, for example, the individual whose case was before the court was someone who fell into one of the statutory categories ineligible for home detention curfew. And, my lords, it's not necessary to go to precisely what they are, but your lordships have seen that there are a variety of people.
Well, give us a paradigm case.
I'm sorry?
Give us a paradigm case.
Well, in terms of statutory ineligibility,
Is it sex offenders or something?
It is sex offenders.
All right, well, that's all you've got to say, sex offenders. Okay,
Yes.
Take a sex offender, right?
Yes. If the appellant's construction is right, they, as it were, gain nothing on the swings of home detention curfew, but they lose out, potentially, depending on the facts, on the roundabout of having an extended licence duration. And the whole point of what the House of Lords decided in Stellato was that to be subject to a longer licence than would otherwise be the case is a real detriment, and that one should not impose that detriment on an individual by way of a strained and artificial construction. But that is exactly what, in my submission, the court would be doing in this case, albeit that the impact would be felt by individuals not before the court rather than by the individual whose case has brought the matter here. And we submit, really, that that is simply something which is wrong in principle. It is I've made the submission by reference to those who are statutorily ineligible. The point holds equally good of anyone who is refused home detention curfew as a matter of discretion, either on the facts of their individual case or because of, for example, the general policy not to allow HDC to those sentenced to terms in excess of 4 years.
But I mean, we're now speaking of post April 05 offending. So that, and if you're wrong on the, I mean, if the court decides a construction point against you, I mean, then they know what they're getting. I mean, the point about Stellato was it would be wrong to interpret the Act so that they do worse in respect of offences committed before the transitional date.
Lord, I respectfully accept that one point in Stellato is indeed that it would have been a case of true retrospective effect. But in my submission, the principle goes further, that the court will not adopt a strained and artificial construction where to do so would be detrimental to individuals in terms of their liberty, as it undoubtedly would be here. Detrimental either in the sense simply that they have to keep complying with a licence at a time when they would otherwise not be bound by it, or in the sense that they may be recalled to prison if they breach the licence conditions at a time when they would not otherwise have been subject to recall. And so we submit that that is a powerful indicator that this is not a case for departing from the natural meaning of the language. And we would also submit that any such departure would in any event go quite a long way beyond what the courts have thought appropriate in other cases. In Stellato, as my lords will recall, and you saw the report yesterday, the House of Lords saw itself as adopting what was in any event the more natural and ordinary meaning of the provisions. In Buddington, the extent of the departure from a strict grammatical reading that was required was to the extent of inserting a comma at an appropriate point. So it was clear that a prisoner who falls to be released was not limited to people falling to be released after a particular date. So again, that was an extremely modest exercise. It's simply not comparable to the extent of the rewriting that the appellant is seeking in this case. The other point I should make is that whilst we have accepted that the construction for which we contend does produce anomalies as between someone who is subject purely to the 91 Act regime and someone who becomes subject to the mixed regime, it is right to say that there is nothing, as it were, intrinsically absurd or unreasonable about the results in terms of the date at which they become eligible for home detention curfew or the date to which their licence extends, nor are they subjected to any retrospective change of the kind that was objectionable in Stellato. So it is in that sense not a strong case for a strained construction. The other point, my learned friend...
To make it work, you almost have to create a statutory regime which imposes judicial implications on what the sentencing judge is saying in circumstances where the sentencing judge can't have the slightest idea as to the intricacies of what he's doing. The example of 3 sentences, 3-month sentence, then a 15-month sentence number 2, and then a 3-month sentence number 3. And then you have to say, well, how is the sentencing judge intending that that shall operate? Oh, well, you have an amalgam of 1 and 3 because the 1991 Act says those are to be treated as one, and then you'll have to say, well, they were imposed first or last. Well, you've got to decide which. And then it's not simply a consecutive sentence, one sentence following on the other, but implicitly the judge is saying, and the second sentence is going to be partly concurrent with the first sentence because it'll take effect as soon as the custodial period of the first sentence comes to an end. And then, of course, the Secretary of State in theory has got a latitude under the first sentence to give some 135 days of release. So the whole thing is pretty horrific.
It is clear that on any view there are difficulties, but what your Lordship is putting to me are practical difficulties in applying the statute to the sentence passed by the sentencing judge. The appellant's construction, on the other hand, involves, so we submit, and I've sought to show, a complete distortion of the words of the legislation itself, and also this impossible task of identifying a custodial period which simply cannot be discharged. And whilst I accept that if it comes to a choice between those two, it might not be seen as an attractive set of alternatives on any view, the construction which fits with the language of the legislation has to be the one that is preferred, even if one then does have to engage in, I respectfully accept, a somewhat artificial exercise in interpreting the sentence in the light of that. That must be, if one likes, the less unacceptable course of action. Well, could I just mention briefly the other point that my learned friend relied upon yesterday to demonstrate that our approach led to absurd consequences was to say that one would, or in certain circumstances, would have concurrent licences in existence. Well, two things to say about that. First of all, provided that the licence conditions are consistent, and I think my learned friend accepted that in reality there was no reason to think they wouldn't be, that is not a particularly absurd or unworkable consequence. Secondly, certainly as we understand the position, the potential for concurrent licences to exist is something that can happen in any event. For example, if one has someone who is given both a determinate and an indeterminate sentence, they're given a life sentence and at the same time a 15-year determinate term, if they're released from the life sentence after 10 years, and if that's also the 2/3 point on the 15-year sentence, if we're on the 1991 Act regime, as we understand it, they will then come out on two concurrent licences, one on the life sentence and one on the 15-year term. So we don't, with respect, think that that can be a fundamental objection. Well, those are really our submissions on the construction of the legislation. Well, Your Lordship took me on to the point about section 154 and how that fits in with this. It doesn't bear directly on the construction of paragraph 14, of course. It simply goes to how this functions in practice. And if we are right that the effect of paragraph 14 is that two sentences have to be separately addressed, then two things follow. You need to be able to say, first of all, which sentence goes first. Well, that will be reasonably straightforward. It will be possible to identify which sentence has been passed first. And then one needs to be able to say when the second sentence starts. And in that respect, what the Court of Appeal has done in circumstances in which the sentencing court is unlikely in reality to have spelled the matter out in a direction, is to lay down how a simple direction for consecutive sentences should be interpreted, where they are a mixture of more than 12 months and less than 12 months. It was suggested by my learned friend, I think, that that involved attributing to the sentencing court a course of action which it had no jurisdiction to undertake under section 154. But in our submission, that is not right. Section 154, in its language, is which is at page 126 of the appendix, is entirely general. Sentence imposed takes effect from the beginning of the day on which it is imposed, unless the court otherwise directs. There is no reason to cut down the power of the court to direct what that day is. It's perfectly correct that in the normal case, it would not be good or proper sentencing practice to direct a date other than the end of the preceding sentence to which it was to be consecutive, because there would be normally be no sensible purpose in doing so. But this situation with which the court is dealing creates an unusual situation in which that does serve the practical purpose identified by the Court of Appeal. Then in my submission there is no jurisdictional objection to that occurring.
Well, you say normally, we're dealing with an abnormal situation. If you postulate any situation in which a sentence is broken into two parts, one part to be served and the other part not to be served, and then you say, and what's the implication of a judge ordering a consecutive sentence? I would have thought the natural thing would always be that the sentence would button on at the end of the custodial period of the first sentence. And so it would be part concurrent and part consecutive. And that's what the statute says, in effect.
Yes, and my Lord, the Court of Appeal's approach here comes as close to replicating that in this situation, one sense of the well, that's really, I mean, our point is no more than
May I
that.
just take up your section 154 point? Can you think of any example of the court directing that a sentence shall not take effect on the day in which it is imposed, other than the occasion when the defendant is not present, because he's scarpered, or because, in the case of the Court of Appeal Criminal Division, when there's an unduly lenient sentence reference and the court decides that the defendant should be sent to prison and orders that the sentence will take effect, for example, on the following day by when he will have surrendered to the local police station? I ask because I've never come across it. A court actually postponing the day when the sentence shall take effect.
More other than in the sense of sentences which are, shall we say, in some sense consecutive. Lord, I can't think of any. Yes, Lord, I can't think of any example of that, and there is in the bundles the case of John Wilkes, which rather suggests that to fix a sentence to start at some indeterminate future date would not be an acceptable thing to do. But Maud, it may be possible to think of other examples in which something would be done similar to what we are postulating here, i.e. not simply for one sentence to follow on at the end of another. For example, I think it has been said that in the case of an indeterminate sentence with a minimum term, the court might properly direct a further consecutive sentence to start at the end of the minimum term of the indeterminate sentence, rather than at the end of the indeterminate sentence. So the idea that one might use the section 154 power to start one sentence going at some point other than some earlier point than the end point of another sentence is not an outlandish idea in my submission. Well, one needs to distinguish between, on the one hand, what the jurisdiction is there to do in section 154 and what would be a proper sentencing practice, and for most purposes such a course of action would not be, but there may be situations, we say, such as this, in which it is proper and does make good sense.
Just remind me of the provision which says the judge has to explain to the...
174.
What would...
Was it 174?
Of the 2003
Yeah, so we got that at page 55, is it? Sorry.
Yes, it does appear.
Where have we got that?
Lord, I have it in tab 10 of volume 1 of the authorities.
It's page 70.
Is it 70? I'm very grateful.
I mean, I do, I mean, the judge in our case, as we've seen, explained it, and on your submission got it wrong. But I mean, the judge presumably does have to explain how long this person's going to be on licence, doesn't he?
Lord, with respect, I'm not certain that is
surely
so.
the sentencing court is not concerned, and never has been historically, with what happens to release, whether remission or under statute now, or licence, or compassionate grounds, or any other considerations.
Well, Lord, with respect, we say that's right, and that indeed is what has been held in the case of Round and...
Round isn't new, though. Round is simply repeating what's been the position.
Don't sentencing judges do what this judge did, which was refer at any rate to the fact that the defendant was going to be on licence after release. He said you'll serve up to half the sentence, and then he explained what he understood to be the position relating to licence. You'll be on licence to the end of your sentence. Isn't that standard?
Not the days.
Oh, not the date. No, I'm sorry. I'm sorry, I didn't put it. But as here, the judge says you'll serve up to half the sentence. Upon your release, you'll be on licence till the end of your sentence.
Well, Lord, I wouldn't dissent from the proposition that probably is a normal way of passing a sentence. But if your Lordship asks me what is the extent of the statutory obligation imposed by 1741B1 to explain in ordinary language the effect of the sentence, I would submit that it is not necessary for the sentencing judge to identify the precise point at which an offender either will or may be released on licence. It would be perfectly adequate, for example, to say that you are sentenced to a term of 3 years. There will come a point at which it is mandatory for you to be released on licence. There may be a discretionary power to release you before, and you will be provided with details of those dates.
Someone else will explain. Well, I mean, that seems to be exactly contrary to the understanding, and I thought that these provisions were introduced in the public interest as much as well as in the offenders, so that the public would understand that release at the halfway stage, for example, was not the end of the matter.
Well, well, if it requires more than, well, I suppose the question is, does it require the court to identify the difficulty with home detention curfew is
that may be a slightly different matter, but your proposition was as wide as that. So there was no duty to explain when he must be released, or to say more than an extraordinarily vague formula.
Well, but I think one can try and test it by the home detention curfew question, because if the effect of the sentence includes the point in time at which you will be entitled to be released on licence, it's slightly difficult to see why it wouldn't also include identifying the point of time at which you might be released on licence. It's difficult to see why one is part of the effect of the sentence and the other isn't.
Well, one reason is that the judge has no control over it.
Yeah.
the judge knows perfectly well what the statute says. You will be released when you've served half that period.
Yes.
After that, it's not under the judge's control, nor is the statute clear, mandatory and binding. The Home Secretary or the Secretary of State can change his policy any time.
And this judge was quite clever too. He also said you will serve up to half the sentence.
Yes.
But I mean, if you're right in your submission, the order in which the judge imposes these consecutive sentences, some under, some over 12 months, is actually going to determine when the licence ends, right?
Yes.
But are you saying that he uses the same rubric in whatever order he passes these sentences? Because if so, I can't see how that does satisfy the section of explaining the effect. I mean, but if he has to explain the effect, I mean, does he also at the same time have to ignore the fact that under one where passing the sentences, the licence will expire at point A, whereas under another order of passing sentences, it's at point B?
Well, my Lord, I would submit it wouldn't on any view be necessary to explain that, because what is to be explained is the effect of the sentence that is passed and not something else that might have been done. So what the learned judge has to say, well, there are, I suppose, three possibilities only as a matter of logic. One is that it suffices to adopt a general formulation of the kind I suggested a few moments ago. Another is to say that the judge has to identify the point in time at which release will become mandatory on licence. And the third is to say that the judge has to identify the point in time at which release will first become possible.
You'll have to forgive me. Under statute, I think that last count there were 17 different things the judge was required to say in his sentencing remarks. Why there was no compensation order, why there was no this, why that, why the other. I don't think we should add to the burdens of the judge guessing at what the consequences will be of whether he decides the sentence on count 1 should be consecutive to the sentence on count 2 or the other way round.
Well, Lord, I hope that's the submission I'm making to urge upon your lordships that whilst in practice, where the position is straightforward, the sentencing judge may spell it out, one should not be anxious to impose, as a matter of statutory obligation under section 174, an obligation to specify that which may in some cases be very complicated. And it's not, my lords, it's clearly not a function simply of the argument I'm addressing in this case about mixed more and less than 12-month sentences. There are many situations in which it's extremely complicated. So my answer would be respectfully to adopt what my Lord Judge says and say, no, one should not impose a mandatory statutory obligation to identify a release point in all those cases. But, Lords, whilst with respect I understand the concern about section 174, it can't ultimately drive the construction of paragraph 14 of the commencement order. The effect of that is whatever it is. It is a fact of life that in some cases release consequences of particular sentences are complex, and either they have to be spelled out or they don't, but it doesn't tell one what they are.
Yeah.
Can I just ask a different consequence of your sequential approach? One sentence comes into effect at a certain point. You say at the end of the custodial period under the main lead sentence, does that mean that in a case like this, where the main lead sentence is treated separately and attracts eligibility for home detention curfew 135 days before the point at which the subsidiary sentences start, the prisoner would be entitled to say, now consider me for home detention curfew?
Well, it does, I think, follow from my submissions that in terms of the statutory provision for HDC eligibility, an eligibility for release on the first sentence would arise at that point. But it is a discretion, of course, and not an entitlement. And in my submission, it would be perfectly lawful for the Secretary of State to adopt the position that it would be inappropriate to release or to entertain applications for release on HDC for people who still had to serve time on another consecutive sentence. So whilst the theoretical position arises, it does not, in my submission, create any practical problem.
I mean, should a judge bear in mind, if he's passing a 1-year sentence and he's contemplating a 1-month consecutive for failure to respond to bail or whatever, should he bear in mind that if he does pass the 1-month consecutive, that's going to cost the 12-month prisoner the possibility of 135 4.5 months HDC?
Well, the logic of the decision in Round and Dunn, which, as Lord says, is consistent with other earlier authority, is that no, that should not be taken into account. It always has been the position that by the difference, a small difference in sentencing could make quite a big difference in terms of release implications. I mean, the difference between passing a sentence of a little less than 4 years or one of 4 years has profound implications. It may well be that in the real world, sentencing judges are not entirely unaware of these matters.
It's one thing to say the judge shouldn't have regard to it when the structure is a deliberate structure which enhances the sentence or whatever once you pass a particular point in time, and a situation where it's entirely haphazard as to the effect that the sentence will have, depending upon the fortuity of whether he chooses to refer to one's count rather than another first. I have great difficulty in saying the judge should close his eyes to the consequences of the latter. It seems quite an extraordinary proposition.
My Lord, the position that the Secretary of State took in Round and Dunn was, as the court upheld, that it should not be looked at. And I've no instructions to depart from that position. But if your lordships were to take the view that that was wrong, and it is a matter that should be taken into account, then it doesn't bear adversely upon the submissions that I advance in this case, because once one has the outcome of this case, a sentencing judge is in a position to know what the consequences will be. And your lordships have no doubt seen the senior presiding judge's letter that was sent out originally after the Heighton decision and subsequently in a revised form following the Court of Appeal decision in this case. So if it is right to take the matter, those considerations into account, then again it can be done whichever construction one adopts.
Then paragraph 14 has had even wider and more dramatic consequences than those for which you're arguing. The entire way in which the sentencing arrangements are addressed by sentencing judges has changed dramatically. Because that's the consequence of your submission, if it's right, of paragraph 14.
I'm sorry, my lord, I'm not certain why that's
But it follows, your submission is that paragraph 14 has certain consequences, not the ones that Mr. Weatherby is suggesting.
Yes.
And if you're right, and we follow the logic of it through, we have to have a system in which judges have to address the issue of time relating to licence, provisions relating to home detention, curfew and the like. Now that would be an extraordinary change.
My lord, I don't, with respect, accept that is the logic of my position. Our position has been, in round and done, and we don't depart from it now, that the sentencing judge passes the sentence in whatever is of an appropriate kind and in an appropriate order, based without reference to these considerations, so it doesn't change the practice at all. All I have submitted was that if my Lord Phillips was suggestion that that might mean the practice ought to change, if that was correct, and it's not what we are arguing for, it would not create any difficulty for the construction argument that I'm advancing here. I'm sorry if I gave the impression I was saying that was what ought to happen.
Well, really, I mean, you're on the horns of a dilemma. You say either the sentencing judge ignores the haphazard, fortuitous, adventitious consequences of your construction, ignores it entirely, or he gives effect to it, in which case, as my lord suggests, then you're completely reshaping the sentencing process. It's one or other.
Well,
Take your
as a matter of logic, that is right, and we have picked the former as our primary position.
I'm not altogether clear why the senior presiding judge took the trouble to write this letter unless he intended judges to have some regard to what he was saying. The only regard they would have was in the sentencing process, wasn't it?
Well,
they aren't responsible for administering the sentence once it's passed.
I think he was telling them to make clear which sentence came first, wasn't he?
Well,
which is the main, which he intended to be the lead sentence. But I agree, it follows that perhaps the implication is he was inviting them to consider the effects.
Well, I mean, simply as a matter of fact, the letter was written, I think, because Mrs. Justice Dobbs in Highton said that sentencing judges should be told how it would work. That may have reflected a belief at that point that it was appropriate to take the consequences into account. I'm not certain. But
Can I ask you a different point? You accepted a moment ago that because the sentences ran sequentially and were to be treated separately, the period of eligibility for home detention curfew therefore accrued in theory, at least under the first sentence, 135 days before the release date. So the Secretary of State's revised slip appearing in the Statement of Facts at paragraph 7 is incorrect, isn't it? Because what the Secretary of State should have said was that there's a home detention HDC. I think he should have said around 1st November 2007 under the first one, because you've got 4.5 months, 135 days, back from around the 13th of March, which is the end of 11 months. So he should have said home detention curfew, 1st November 2007 to 13th March 2008, because it would then come to an end when the second sentence began. And then he should have said second period of home detention curfew from 20th of April 2008.
well, I take your lordship's point that if for strict accuracy that would be right. I don't know what the current practice is, for example, in relation to people who are statutorily eligible for HDC, but because they're serving more than 4 years will not normally be considered. It may be that a way of wording a notification might be to say that the eligibility date for home detention curfew on your second sentence is whatever the date is, and to indicate in some standard footnote that the Secretary of State would not release on HDC under a first sentence when there is a second consecutive sentence still to run. So, well, I take the point that one can question
Well, why would he not release? Because in practice it would be impossible to recall.
Well, because it would be seen as it would be regarded as undesirable to release someone in circumstances in which they would have to be recalled again.
Section 265 expressly prohibits producing that result.
In a slightly different context. Yes,
yes,
exactly. And the Court of Appeal in this case certainly thought that that would be a wrong result. I mean,
but it does underline the point that you say the sentences should be treated separately. The recent statute, the 2003 one, clearly intends that there should be this possibility and period, and yet the effect of your submission is that it becomes impossible to grant it.
Well, not statutorily impossible, but the effect of my submission is that it would not in practice be granted. Under neither of the, as it were, complete regimes, neither under the 1991 Act regime or under the 2003 Act regime, has it ever been contemplated that someone would come out on home detention curfew following only a part of the overall sentencing disposition. We're saying that the position in the mixed case with which we are contending is exactly the same in practice. It's simply that because the commencement order does not contain the aggregation or single terming provisions that one finds in the two regimes considered separately, you have to get to the same result as a matter of practice. Practice in the exercise of the discretion. So it produces no alteration or anomaly of substance. It is, if one likes, a further illustration of the fact that having these two regimes simultaneously in operation does create difficulties and complications. I mean, and I hope I haven't tried to make a secret of that in my submissions. But the bottom line, we still say, is that one cannot make provisions apply to a sentence of 12 months where the commencement order says they're not to be of any effect in relation to any such sentence, and one cannot make up a custodial period for a sentence of less than 12 months where there simply isn't one to be derived from the legislative scheme. And if those propositions are right, then the other resulting practical difficulties just have to be addressed.
Mr. Noone, I certainly don't want to complicate matters any further, but is whatever the decision we take here with regard to under 12-month sentences, does it necessarily impact on pre and post mixed pre and post April 05 crimes?
I think the short answer to your Lordship's question is no.
So we needn't be troubled by that aspect at all.
Well, that is the only part of my submissions that I potentially still have to deal with, the question on paragraphs 19 and 25 of the schedule. And what I was going to say to your Lordships was, we do have there are points to make about that. We would respectfully adopt what I think at one point Lord Mance put to my learned friend yesterday, that it was at best, I think a soft nudge was the phrase, or a relatively peripheral consideration in the construction. The difficulty with it is that dealing with it all is quite complicated and tends to become a bit disproportionate to the relevance of the point. What one can certainly say is that paragraph 19, which is the key paragraph about pre and post, on any view takes a fairly strongly different approach from paragraph 14 in particular, and most obviously, whereas paragraph 14 disapplies the whole of sections 244 through to 268, so including 263 and 264. Paragraph 19 does not. Now, what actually flows from that in terms of practical consequences is a matter for debate and potentially lengthy debate. But if there is a difference, then in my submission it flows from that difference in wording, and therefore what the court decides about the effect of paragraph 14 does not inexorably determine how it works with 19 and 25. On that basis, I'm, for my part, quite content either to leave 19 and 25 aside, or if your Lordships think that they do potentially cast significant light on the construction of paragraph 14, then of course I ought to deal with it, but it's difficult to do so in a sentence or two, I have to say.
May I raise a connected point? And it's late thoughts, and I haven't resolved it to my own satisfaction. We've worked in relation to paragraph 14 to offences covering both the coming into force of the 2000 sentences, rather, coming into force both in relation to the 2003 Act and those imposed under the 1991 Act. I'm just wondering why we're making a saving for prisoners serving sentences of imprisonment, unless it is simply to ensure that those who were sentenced before the coming into effect of the 2003 Act have to have some savings. And the object there may simply be to ensure that those who are serving sentences imposed before the coming into force of the 2003 Act shall continue to serve them in accordance with and under the provisions of the 1991 Act.
Lord, so...
And therefore, if I may just finish the thought,
sorry, Lord.
And therefore paragraph 14 may have nothing whatever to do with the 2003 Act. Now, I'm sure I'm wrong, but could you tell me why I am?
Lord, so your Lordship is postulating that it is, if you like, a transitional provision in the strictest sense of a temporal transitional provision. It's for the ones already inside, as
Exactly.
it were. Lord, I don't think with respect that can be right.
No, I suspect it isn't, but you've got to tell me why.
If we just take the very simple case of someone who this morning is sentenced to an 8-month term of imprisonment, the 2003 Act regime cannot apply to that individual because it has deliberately not been brought into force, because it would have to be on the custody plus basis and with release on licence, and that's all the resource and policy issues. So you haven't got the 2003 Act for a less than 12-month sentence passed now all you have got is the 1991 Act. And therefore, whilst I take my Lord's point about the present participle in the heading, I think it is common ground and must be the case that it is a saver which applies to sentences of less than 12 months going forward. It's just a question of
Whenever imposed and under whichever statute.
well, if they're imposed now, they're imposed under the 1991 Act because it's sorry, a minute more. That was wrong. Forgive me. Yes is the answer to your Lordship's question.
Whether they were sentenced before or after.
Whether sentenced before or after.
So, I mean, the heading should have been saving for prisoners sentenced to imprisonment of less than 12 months.
Yes.
Yes.
Another infelicity of the drafting.
My Lord's way of putting it is consistent with the way sections 263 and 4 operate, because it has been sentenced.
My Lord, yes.
Thank you.
I'm not quite convinced by your answer. An 8-month sentence of imprisonment imposed now to run consecutively to a 3-year sentence which is still being served. Doesn't it beg the question as to whether the 2003 Act has any effect?
My Lord, yes, but I think my Lord Judge is postulating a much simpler dilemma. Suppose you, never mind all the difficulties of consecutive and concurrent sentences. If I understood my Lord's question right, let us simply assume someone who is sentenced to a term of 8 months and nothing else. Is paragraph 14 only concerned with the people to whom that happened before the 4th of April 2005, or is it concerned with the people to whom it goes on happening until the regime changes? And my answer is it is concerned with both and has to be.
But I mean, there's no further alternative, isn't there? That this was simply focusing on the position of somebody who's already serving a sentence, who has another less than 12-month sentence imposed, consecutive to the one he's serving.
Yes, Leonard Jr. is making the point that it does say whether or, in the brackets. One thing the brackets certainly indicate is that it applies whether or not it's concurrent or consecutive with another sentence of less than 12 months.
Yes, yeah.
But,
It's another such sentence.
Lord, I think the reason why this point is common ground is that any alternative reading of paragraph 14 would leave
Even bigger lacuna than the one that's there.
a lacuna big enough to swallow up the system, I think. It's,
Very well.
Is it a consequence of your argument on paragraph 14, of the argument that if it doesn't apply to a sentence of imprisonment of less than 12 months, which is imposed consecutively to a sentence of longer than 12 months, then, as a matter of language, all the sections 244 to 248 must come into effect, and sections 33 to 51 must be repealed of the 1991 Act. And this is a consequence of that, in fact, the leaving aside the difficulty that you wouldn't then have a custodial period, is it a consequence that, in fact, you would have a home detention curfew period which would begin 135 days before the halfway mark of a sentence of less than 12 months, which would virtually eliminate the custodial term served?
because the 2003 Act provision would have taken over.
Yes, I mean,
Yes.
I think the argument about lack of a custodial period is part of consequence of a wider argument, namely that literally, on the appellant's construction, all the provisions, so far as they have been brought into effect by Schedule 1 of sections 244 to 268, come into force, and all the sections 33 to 51 of the 1991 Act disappear.
Yes.
And if you look at all the provisions of the 2003 Act, of course, some of them haven't been brought into effect. 181 is not a relevant one here, but section 244, 3, B and C, for example,
yes,
is excluded, which is part of the problem. But section 246 is not excluded, is it? That's in force.
That is in force.
And
yes.
so you would find yourself then on your, you say, on the appellant's approach, applying a release on licence, at least an entitlement to request release on licence 135 days before the halfway period, if you could get a halfway period. I mean, your basic point is that you have difficulty finding a halfway period because it's been abolished with the abolition of Section 33.
Yes.
But if you found a halfway period, you then have a right to ask for release on licence 135 days, 4.5 months before the halfway period, which in a sentence of less than 12 months means after a maximum of 1.5 months. Am I wrong?
Well, you've got little two that would...
yes, of course, you have to serve at least 6 weeks.
Lord,
So,
yes,
well, that's 1.5 months.
Well, Lord, I'm reluctant to look what possibly might be a gift horse in the mouth, but I wonder if I think my learned friend would say that on his construction,
yes,
you don't do it. The requisite custodial period is the aggregate of the custodial periods for the longer and the shorter. That follows from 246 6. Yes. Read with 2443D.
Yes, I see. So you avoid all. I'm falling into the fallacy of mixing two regimes. Effectively, if you go along with his argument, then you avoid that.
Yes. Well, I think I have to accept that my learned friend's argument is, as it were, internally consistent, except that it has this hole where you need to identify a custodial.
But your basic point then is the good one, or you say, and namely that there simply isn't any requisite custodial period at all because Section 33 is gone.
Yes.
Yes.
Well, I think on the footing, I don't need to trouble your lordships with paragraphs 19 and 25. Oh, I should have, just as a factual matter, I'm instructed. My learned friend said when asked about the practical implications, if any, for Ms. Noone, there was an issue about whether she might have been unlawfully at large. I'm instructed that the Secretary of State, in fact, gave a formal direction for the avoidance of any doubt that the days spent on release after Mr. Justice Mitting's order should count towards the period in custody, so that factual loose end has been tied up, but it's that's for the record, and there's no practical bearing. Is there anything else, Stephen? No. Well, then, unless I can assist further, those are my
No, thank you very much. Mr. Cobas? Yes, Mr. Welby.
My Lords, I can be quite brief, I hope. In respect of the point the learned friend raises about subsection 6 of 264, we've made lengthy submissions about why that's not an exhaustive definition.
Yes, that is true, but so far as I'm concerned, he has raised a point of substance by saying there isn't anywhere, because you can't now have resort to the 1991 Act to find a custodial period of half the sentence, because that no longer applies.
Well, I'm coming through subsection 6 to end up at that point, my Lord. The fact is that looking at subsection 6, it isn't an exhaustive definition, whether by design or not. It isn't exhaustive, and therefore it is possible to look elsewhere for custodial period. Another friend goes on to remind us of what Mrs. Justice Dobbs said about the mixing and matching of the two sets of provisions, and in particular section 33. In our submission, that's precisely what transitional provisions do in some circumstances. And the good example of that is Stellato, where in Stellato, my Lords held that the combining provisions, or rather the new recall provisions were brought in, but the substantive provisions of the 1991 Act still applied. So there was precisely that mixing of provisions between the new Act and the old Act. So there's nothing inherently unlikely about that happening in a matter such as this. Now, the mechanism that we say pertains here is that for the sentences which are greater than 12 months, obviously there is no difficulty, because they are dealt with by subsection 6 itself. The combining provision is subsection 2, because in terms of multiple sentences, paragraph 14 is read in the singular, and therefore 264 is not disapplied. So the combining provision, the operative combining provision is subsection 2. However, under subsection 2, what one then has to do is to look at the individual sentence. The individual sentence, as I say, under the 12 months plus.
This particular sentence we're looking at,
yes,
because it's being served consecutively to a sentence of more than 12 months, is not a sentence to which paragraph 14 has any application.
Well, with respect, that isn't my argument. My
right.
argument is a mixing of the provisions. The paragraph 14 does not apply to the combining of the two sentences, and therefore section 2642 applies, so that you have a mechanism. It brings in the combining mechanism because paragraph 14 has to be read in the singular. But maintaining reading it in the singular, when one comes to look at the relevant provision for custodial period, then paragraph 14 does operate in terms of the calculation of the custodial period for sentences of less than 12 months. In terms of the aggregation process, this is not a single terming process. This is an aggregation of individual sentences.
But what you're aggregating?
Well,
sorry.
If it's aggravating individual sentences, then one isolates the less than 12-month sentences and then applies paragraph 14 to the individual sentence. So in terms of calculating the custodial period, section 33 is saved.
How do you get that out of paragraph 14?
Well,
Being given two different functions in two different contexts.
In relation to this particular sentence,
well, the first question is, how do we combine this multiple sentencing exercise? And we say that because paragraph 14 has to be read in the singular, that does not disapply section 264. And so in terms of combining the sentences, there's no difficulty, and it's done by section 264(2). Once we reach that stage, looking at 2642, that then combines individual sentences, or the calculation of custodial periods of individual sentences.
which is a bit different.
Well, precisely,
Yes.
but my submission is that when looking at individual sentences, paragraph 14 applies. So paragraph 14 doesn't prevent the combining under section 264, but it does save the provision for calculating the custodial period, the individual term.
It saves section 33,
Yes.
saves the application.
Because once you've combined the sentences under section 264, you then have to go back and look at the individual sentence to calculate the custodial period of the individual sentence, which then is put into section 2642 and aggregated. So there's no difficulty with that.
I mean, what you're really saying is that paragraph 14 is dealing with problems of aggregation only. Is that right? It's directed
well, no,
to...
the way I come up with paragraph 14 is that the instruction to the draftsman must have been, we're not bringing in section 181 at SEC. Therefore, we need to save the 1991 Act provisions. So the starting point is to disapply the provisions of early release for a sentence of less than 12 months. The draftsman then gets to section 264 and then realises that there is a difficulty in terms of combining sentences if one simply disapplies the 2003 Act provisions. In particular, there's the licence lacuna difficulty with the non-application of 2644 and 5. So the provision remains in the singular because it's primarily directed at the calculation of individual sentences. And read that way, it doesn't disapply the combining mechanism, save in the circumstance of the parentheses. But when one gets to the combining of the two sets of sentences under section 264, then one is looking at an individual sentence in terms of the calculation of the custodial period. So for that purpose, paragraph 14 does save section 33, in the same way as it saves it for a freestanding sentence of less than 12 months. The key is to read paragraph 14 as applying to singular sentences. The disapplication the disapplication of the combining provisions only applies to where all the sentences are less than 12 months. So there isn't a lacuna.
But isn't your problem that section 264 is not a section which aggregates two sentences, but a section which deals with release on licence in relation to two different sentences?
Well, it firstly combines two aggregate custodial periods, and then under subsection 3 provides the licence to run to the end of the combined sentence.
It doesn't, as it were, combine them. It says that they have to be added together for a purpose of a particular computation.
Yes.
It's quite different, isn't it, from a provision such as the 1991 Act, which says that where you have two sentences, they are to be aggregated and treated as a single sentence.
Well, yes. I mean, it changes the device by which sentences are combined.
Yeah.
Precisely, yes.
Yeah. And I have great difficulty in seeing how you can say that for the purpose of section 264, it is to be treated of effect in relation to a sentence of imprisonment of less than 12 months. But for the purpose of the repeal of section 33, it is not.
Well, the answer is simply that it's drafted to apply to single sentences. So where one is considering the single sentence, which one is when calculating the custodial period for the purposes of section 2642, then it saves section 33. Because otherwise one doesn't have a method of getting the custodial period.
It seems to me on analysis that section 264 is also dealing with single sentences. Nothing in this chapter requires the Secretary of State to release the offender on licence until he has served a period equal in length to the aggregate of the custodial periods in relation to each of the terms.
Yes. The difference between section 264 and what was the position hitherto was that under section 51, one created a single term and then applied the early release provisions, for example, section 33, whereas here it's the other way around. So we aggregate the custodial periods. We don't aggregate the term and then work out what the overall custodial period is. Yeah. We aggregate each of the individual terms. So in terms of calculating the custodial period of each individual term, we can do that under subsection 6 for the over 12-month sentences, but we have to look elsewhere for the less than 12-month sentences. Paragraph 14 applies to individual sentences, and therefore...
Sorry, isn't section 264 also applying to individual sentences? You've got to identify each individual sentence in order to find what the custodial term of that individual sentence is, in order then to do your computation of when the defendant is going to be let out.
Yes, in terms... Well, could we put the real figures in?
Yeah.
Here we have a sentence of 22 months. That 22 months is calculated... The custodial period for the purposes of subsection 2 is calculated by subsection 6. The 5-month...
but you start off here, we have a sentence of 22 months, but it's not right, is it? Here we have a sentence of a number of different terms.
Well, there are...
It's the terms. I mean, the single sentence is dealing with terms to be served consecutively. We're really focusing on terms.
Well, the sentence of the court is 22 months and, in effect, 5 months. So there are 2 sentences of imprisonment. If they're to be combined under section 264, under subsection 2, one then has to work out the length of the custodial period in respect to the 22-month term and the length of the custodial period in respect to the 5-month term, and then add them together. If one does that, the mechanism of doing that is through subsection 6 for the longer term, and via paragraph 14, because it's an individual sentence, saving section 33 for the 5-month term. And the 2 answers are then aggregated under section 2642. In my respectful submission, that there isn't a difficulty with that. So paragraph 14 doesn't prevent the combination provision applying, but it does save the custodial period, because by that point we're dealing with an individual term.
You're really saying that paragraph 14 is only applying in relation to sentences of imprisonment of less than 12 months when you are focusing on them
as an individual
as
sentence.
an individual sentence.
Yes.
Once you've identified, and it doesn't matter whether they're concurrent or consecutive with other sentences of less than 12 months, once you've identified what they are, you say
Precisely.
that section 264 isn't focusing on individual sentences, it's focusing on aggregation of sentencing.
It's the aggregation of the individual terms which are calculated by the Parent Act.
I hear what you say, but it does seem to me 264 is not aggregating terms at all, really. You've got two terms, each of which would, on the face of them, require the Secretary of State to let somebody out. But this is saying, well, if there are 2 there, you can't let him out on either until the period that's been served is the aggregate of the period to be served on both.
I'm sorry, I think I've been at cross purposes with my Lord. I'm simply trying to trace the mechanism by which we get to the aggregate under 264, by which the release date can then be calculated, or in this case, the HDC date can be calculated. And that's by reference back to paragraph 14 in my submission. And in terms of the operative section, in terms of in respect of HDC, learned friend correctly characterises my argument, which is that the HDC falls under 246, but 246 refers back to 2642. So there's no difficulty in terms of the operative section in respect of HDC.
And when you get to subsection 3, for the licence, where any of the terms is a term of 12 months or more, which implicit in which is you can have it added to it as here a term of less than 12 months,
Yes.
then you're on licence until the aggregate whole length of both.
Yes, which is the scheme of the 2003 Act,
Right.
which provides for licence to be sentence expiry date. And as the appellant was serving sentences which were all committed after the commencement of the 2003 Act, that's precisely what one would expect.
And the only thing not brought into force are 4 and 5, where each of the terms is less than 12 months.
Yes,
Because you recognise that, as far as those are concerned, it's 14 encompasses all aspects.
and it has to,
Quite.
indeed. In respect of section 154, can I just return to that briefly? I think this is my last point. If the respondent is right and there is no statutory combining mechanism, one has to fall back on basically essentially an assumption that common sense indicates that sentence 2 starts at the end of sentence 1. In our submission, common sense is a strong facilitator of statutory interpretation, quite obviously, but it isn't a substitute for a statutory provision. And the difficulty with the Secretary of State's submission on this is that he can't escape from the consequence that in fact sentence 2 does not start at the end of sentence 1. It starts and often finishes during the currency of the licence period of sentence 1, and therefore it is concurrent. My Lords, unless there's anything I can assist with, those are my submissions.
No, thank you. We're grateful to Council for their submissions and will take time to consider our judgment.
We're going to